Hello students, welcome to the class of Cybersecurity, Unit 5. Today we'll discuss a Semiconductor Integrated Circuit Layout Design Act 2000, which is applicable in the domain of India for the protection of semiconductor layout designs. It is a part of IPR or Intellectual Property Rights. Let us start with what a semiconductor is. A semiconductor, as the name is suggesting, it is a material having conductivity in between conductor and insulator. Popular semiconducting materials are silicon, gallium arsenide, etc. These are building blocks for all electronic ICs, including processors, transmitters like Pentium processors, quad-core processor, i3, i5 processors, AMD processors, Snapdragon processors, transmitters, receivers, satellite system, rocket propulsion systems, advanced digital designs, media devices, etc., etc. All are made up of semiconductors. The semiconductor materials also find applications in solar cells and all kinds of sensors and actuators. That is why modern instrumentation is so heavily dependent upon semiconductor. Now, what is an integrated circuit or IC, also called as a chip as a short form? An IC or integrated circuit is a small semiconductor wafer where lots of active and passive elements have been placed and interconnected. All the elements are electronic and electrical in nature, and they are interconnected in such a way to give a specific input-output combination. Now, before 1984, designing or making a chip that has identical design with existing chip did not require any legal permission from the owner. You can copy it. In other words, copying the layout of the chip was not illegal, but this led to huge loss for the companies who were really designing the chips like Intel and etc. So Intel, along with the Semiconductor Industry Association or SIA, took the lead in seeking remedial legislation against the chip piracy. In 1984, the United States enacted the Semiconductor Chip Protection Act of 1984, the SCPA, to protect the topography, that is the design of the semiconductor chips. The SCPA is found in Title 17 US Code section 901 to 914. Now, each layout and design of a semiconductor chip is a unique combination of transistors, diodes, active and passive elements, which is a property of the company or the person who is developing it and manufacturing it. Illegal copying of an integrated circuit design can cause the original company who has put all its efforts a good fortune, and it will be deprived, the company, original company will be deprived of its share in the market, which can be totally disastrous. So the intellectual property right in this field of the semiconductor layout design is extremely important, and it finally came out in India in the year of 2000, and it is known as Semiconductor Integrated Circuit Layout Design Act 2000. It provides the mechanism for the protection to all semiconductor layout design which are registered in India. It came in the year of 2000. The main features are: the act is applicable in the domain of India. The layout design has to be registered with the SICLD registry for availing IPR protection. Protection under the act exists only after the layout design has been registered only. Now, what are the conditions that a layout design can be registered? Let us see. It has to be original, inherently distinctive, capable of being distinguishable from any other registered layout design. It has to be distinct for any other registered design, and if they have not been commercially exploited for more than 2 years before the date of application of the registration. Thus, the Act does not require very much novelty, but it has to be distinct in some way with the already existing and registered layout designs. So this Act lists the IPR rights, intellectual property rights, which the registration provides. It provides that an appellate board can be used for a forum of discussion. You can always appeal to that particular board. It specifies how the royalties have to be handled. It also specifies penalty in case of infringement of this layout design happens. Now, what is the duration of the protection? Protection of 10 years period is provided to any kind of layout design which is registered. There are provisions for determining payment of royalty for registered layout designs in case of innocent or unintentional infringement. If somebody does it without knowledge or out of innocence or any kind of not malified intention, then there is also provision for determining payment of royalty. Now, penalties in the form of imprisonment in IPC and fine are imposed for willful infringement and other offences in the Act. The steps involved for the registration of a layout design are: the creator of the layout design needs to file an application form and submit it with the SICLD register. The application may be accepted or rejected or accepted partially, requiring certain modifications. The accepted applications are advertised within 14 days of acceptance. 14 days of acceptance. After it is accepted, within 14 days it is advertised, and from that day up to 3 months wait period is given for filing any kind of opposition. If somebody wants to file an opposition to say that no, this particular design is already been created and registered with the SICLD, then 3 months is the wait period. In case opposition is filed within the 3 months wait period, a counter statement to the opposition by the original proposer can be filed within 2 months from the date of receipt or notice of opposition. Now, in case of a conflict, the registrar may take hearing from the parties and has the discretion to grant or reject the application on the basis of conclusion of the hearing. Thank you for your kind listening. Bye.